Hello, my name is Suzanne Clark. I'm an attorney with Jimerson and Cobb, and today I will be discussing mobile device discovery. In today's presentation, I'll be going over some practical ideas for dealing with discovery, and also we will get into the rules and case law relating to mobile device discovery. I wanted to begin with a little bit of terminology so that for anybody out there who needs to get up to speed on some of the common e-discovery terms, you will be prepared for that and able to follow the presentation. I may be talking about ESI quite a bit. That's electronically stored information. That's the common industry term in e-discovery and legal industry relating to the data that is dealt with as evidence within litigation. A custodian is a person or entity that is responsible for ESI. For example, you would be the custodian of your emails, your cell phone, and the files on your computer. And a very important term that relates to mobile device discovery is metadata. The reason metadata is so important, and we will get into this further, is that a common issue in litigation is a producing party changing the form of the evidence when dealing with electronic evidence. For example, printing an email and producing a printed copy of an email takes away all the metadata. Metadata is data behind the data. For example, some basic image files have almost no metadata, but a Microsoft Word document contains hundreds of pieces of metadata, including when the document was created, printed last, and last modified. So that is a very important term, especially in mobile device discovery if you're wanting to actually deal with the electronic evidence and not, say, a print screen of text messages. So you want to request the production of text messages. Now what? Again, we're going to be dealing with form of production. How do you get the form you want in order to have the metadata and be able to discern if texts were deleted? This is the idea that screenshots are not good enough. Metadata will give you the time, date, sender, recipient, images, information about images, location, and information on whether data was deleted, forwarded, etc. An important issue in mobile device discovery is whether you need to collect a forensic image of a mobile device or if there are other defensible and targeted collection techniques that you can deal with. So let's be practical. How do you convince a judge to let you image a mopile device? A judge who is thinking about his own cell phone or smartphone and tablet and how he wouldn't want an opposing party in litigation to have his entire cell phone. Start with the rules. Before you even get a judge involved, you have the Florida Rules of Civil Procedure that can assist you with this. A great tool with mobile device and electronic discovery collection is to use interrogatories. If you can demonstrate a party's mobile devices, social media, and app usage from their answers to interrogatories, you are more likely to be able to convince a judge there is relevant data on the devices. Questions that you want to ask, information that you want to discover through your interrogatories, or things such as what mobile device do you use and have access to? Work phone, personal tablet. Who else has access to your mobile devices? Do you use two-factor verification? What apps do you use for email? What apps do you use for texting? A lot of times we assume that the little green app with the white message box is what we need to collect, but if somebody is texting internationally, they might use WhatsApp. They could use Skype, FaceTime, Slack, Google Hangouts. Also, ask what social media apps does the litigant use on their phone. This is another way to gain access to social media evidence besides going through the social media website. Are your mobile devices linked? If they've deleted text message from a phone, but their texts are also linked to a tablet, those messages might be available on the tablet. Do you back up your phone to a PC, Mac, or the cloud? If you ask these questions, then a judge could see that this phone is very relevant to the litigation and you need to obtain the evidence off of it. You can find definitions to terms like app, the cloud, just by doing a simple Google search. If you're dealing with a judge and perhaps she is not tech savvy and you know this, you're going to want to be able to define those terms for opposing parties as well. Take advantage of your client's right to specify the form of production of ESI under Florida Rule of Civil Procedure 1.350B. Under this rule, a request for electronically stored information may specify the form or forms in which electronically stored information is to be produced. Take advantage of this. Don't just use your form request for production that's saved on your server. Go ahead and edit it for your particular case. If you're dealing with emails and you want those emails in a certain form, specify that. If you're dealing with a mobile device, say how you want to receive production. You have the right to do that, so go ahead and specify. If it needs to be worked out, the other party can object and you can sort that out, but see what you can get up front. You want to collect a forensic image of a smartphone, but what about privacy and non-responsive data? Again, as I mentioned before, a judge may be concerned about private and non-responsive data being produced if you are getting a forensic image of a phone. It could be something that's embarrassing, and a judge isn't going to want that to be produced, so you need to be able to convince the judge you need the forensic image in order to get your relevant data and figure out a way to sort out private, confidential, privileged data. The inverse is also true. You can use the rules to protect your client as well, and you need to be prepared for the limitations on discovery of ESI that the Florida rules present so that you can be prepared for an opposition's argument as well. Rule 1.280D governs limitations on discovery of ESI in Florida. A person may object to discovery of electronically stored information from sources that the person identifies as not reasonably accessible because of burden or cost. This deals with the inaccessibility argument of the proportionality analysis. In determining any motion involving discovery of electronically stored information, the court must limit the frequency or extent of discovery otherwise allowed by these rules if it determines that. And part 2 is the burden or expense of the discovery outweighs its likely benefit, considering the needs of the case, the amount in controversy, the parties' resources, the importance of the issues at stake in the action, and the importance of the discovery in resolving the issues. This, again, is a proportionality analysis. It was added to the Florida Rules of Civil Procedure with the 2012 amendments. It is also a very important part of the Federal Rules of Civil Procedure, Rule 26. In Florida, we also have Rule 1.410, Subpoena, and dealing with subsection C for production of documentary evidence, including electronically stored information. The court on motion may quash or modify the subpoena if it is unreasonable or oppressive, or condition the denial of the motion on the advancement of reasonable cost of production. This is the cost-sharing and cost-shifting arguments that you can deal with in when you're dealing with expensive electronic discovery and mobile device discovery. A person responding to a subpoena may object to discovery of electronically stored information from sources the person identifies as not reasonably accessible. There we are again. and on motion to compel discovery or to quash, the person from whom discovery is sought must show that the information sought or the form requested is not reasonably accessible because of undue cost or burden. If that showing is made, the court may nonetheless order discovery from such sources or in such forms if the requesting party shows good cause, considering the limitations set out in Rule 1.280D2, which we've discussed previously. Any and all, most attorneys have any and all and request any and all of certain documents within their discovery. With the volume of electronically stored information, it's impossible to produce all relevant data, and this was much of the reason behind the amendment to Rule 26 of the Federal Rules of Civil Procedure, the December 1st, 2015 amendments. Within the committee notes, the former provision for discovery of relevant but inadmissible information that appears reasonably calculated to lead to the discovery of admissible evidence was deleted from Rule 26 because now it is essential that the proportionality analysis be conducted. As previously discussed, this proportionality analysis is also in the Florida rules. The idea being that reasonably calculated to lead to the discovery of admissible evidence is too broad. A proportionality analysis needs to be conducted to address the importance of the issues at stake in the action, the amount in controversy, etc. Important ideas to consider here are that if your opposition is requesting voluminous data, if it's overly burdensome, if it's expensive, if they are, for example, in an employment dispute, a former employee is asking for emails across 100 company locations, dozens of custodians, if their any and all request is dealing with that amount of data and those numbers of custodians, it would be appropriate to object, and within the objection to conduct a bit of a proportionality analysis and give a narrative explaining what the controversy is and why that amount of data is overly burdensome. Then hopefully, in the spirit of cooperation, you and opposing counsel can deal with narrowing the scope of the discovery without having to have a hearing. Again, inaccessibility and mobile device evidence. If text messages are determined to not be reasonably accessible because of undue burden or cost, the parties seeking them in discovery may be required to establish good cause and share in the cost of retrieval. If we go back and look at our proportionality analysis, we are going to consider the amount in controversy. If it's a small amount in controversy, is it worth $500 to image a cell phone? Can the producing party afford that? What are her resources? How important are the issues, and how important is having a forensic image of the mobile device to the discovery and the litigation? So an analysis will simply need to be conducted, and good cause will need to be shown to the court. Next, we'll look at some Florida case law with regard to proportionality. There's an excellent Florida Bar Journal article on proportionality. That particular article deals with pre-litigation preservation and proportionality. So proportionality not only deals with production, but also with preservation. And we have a nice quote here from a footnote from the article. Proportionality ensures that the burden of production and discovery does not outweigh its benefit in light of the value of the case. And we have a case site here if you need to reference case law in this matter. There are other methods of collecting smartphone data that preserve metadata without the need for a full forensic image. It has become common in electronic discovery collections, especially dealing with email, that it is not necessary to image an entire computer unless there is concern that someone is hiding the ball. Often, collection experts are now collecting targeted collections. They're collecting, for example, a custodian's user profile and grabbing all of that custodian's data rather than the entire machine. They're grabbing that custodian's email, and then the attorneys can hash out searches of that email, but it has been collected. There are also possibilities for doing targeted collections of cell phones. However, when you look at the expense of having a project manager come in and take their time to collect, it might be 6 in one, half dozen in the other, between just going ahead and imaging the device, putting it on a shelf, and deciding with the other side what you're going to take off the device, versus having a project manager come in and pick and choose what gets collected. So this would just be something that you weigh on a case-by-case basis. Or if a judge is adamantly against forensic imaging for privacy reasons, things like that, at that point you may want a forensic examiner to come in and just pick things out and do a targeted collection to be less intrusive. But keep in mind, you will need a full forensic image if you think someone is trying to hide the ball or has deleted data. How to search for text messages. It's simple. You can go into the app and search if you have an iPhone. Otherwise, you can get software that can assist you with searching. Who should perform a search? This is a consideration in the e-discovery industry and in best practices of who should be searching data. Should you have a neutral vendor, self-collection by a party, an attorney? There are pros and cons with each of these. A neutral vendor is going to cost more. However, that is the most defensible way to deal with collections of electronically stored information. You can have that vendor testify. The vendor is neutral, has no reason to try to hide data or not collect all the data. Both sides are going to be more comfortable. Of course, you have to pay them, you have to retain them, you need to vet them. So many times, parties, especially with smaller amounts and controversies, are going to want to do self-collection. The problem with self-collection is parties will self-cull. So culling is something we will discuss when we discuss keyword searching in a little bit. But self-culling is the idea that if a party is doing their own collecting, they're going to go through and say, oh, I think I know what's relevant. They're going to run searches based on their recall and not based on what's actually in the data. They may not think of something. They may be making judgment calls about what's relevant and what's not relevant, when really you should collect everything that could potentially be relevant, and the attorney should then search it. Collect by a vendor who can testify about their collection methods, and then have an attorney analyze the legal situation, what's relevant to the lawsuit. Of course, best practices and practical reality can differ, and you have to go on a case-by-case basis and decide what risks and return you're dealing with in your particular matter. Keyword searching. From an attorney's perspective, what things do you need to keep in mind? One tip that I recently learned from a webinar I attended is remember to search for common misspellings. There's a great website for that, dumbtionary.com. If you want to make sure you're searching out everything, find out how the word is commonly misspelled and add that to your search as well. Use pre-search culling to remove redundant or non-responsive data. Culling is a broad term that is simply the act of removing documents from a collection in an attempt to reduce the size of the collection. Some standard ways to cull are denist, deduplication, applying date ranges, running search terms, and some forms of analytics. Denist is taking the NIST list, which is a list created by the National Institute of Standards and Technology, NIST. They have a running list of non-user generated document signatures that they have established as having little or no value for litigation purposes. In other words, denisting is an industry-accepted list of junk files, most program and system files that do not contain user-generated data. When you denist a collection of ESI, you are simply removing these industry-accepted junk files from the collection. An example of files that would be removed during this process would be the files that are created on your computer when installing a new program such as Adobe Acrobat Reader onto your computer. Always test searches before agreeing to them with opposing counsel. It's often difficult to anticipate what searches will return and what keywords will return in a search. So it's a good idea to test that out before sitting at your Rule 26F meet and confer conference or a case management conference in state court when you may be in the hot seat and have pressure to go ahead and agree to terms, and opposing counsel may shoot over some terms that look reasonable, and then when you run searches you find out you're dealing with a lot of false hits and things like that. So test out your terms before you agree. If opposing counsel is pushing you to agree, then go ahead and ask them for an enlargement of time to get these search terms to you. Be careful of false hits on wildcard searches when you're using quotes and asterisks and question marks. See morewords.com. For example, you may find that the beginning of your word may return 300 words in the English language, so be careful about using wildcards. Keep a list of noise words and structure your search around them. Document your search efforts to show due diligence. Use a spreadsheet. And all of these tips and much, much more can be found at this webinar here that was that Cloud9 gave on January 26th. Excellent webinar. You can go to the website, sign up, and get a full hour on best practices for e-discovery searching. So, now you're at your hearing. How do you convince a judge to let you image a mobile device, or at least have a targeted collection? Again, go for getting an image. That's your best bet. Even if you have to put it on a shelf and hash out later how you are going to collect from the imaged device, you want to avoid spoliation, you want to avoid deletion of data, lost cell phones, overwritten data, negligently overwritten, or in bad faith, intentionally deleted. All of that can be avoided if you simply grab an image of the phone. So how can you convince a judge to let you do this? You need to be able to explain why screenshots and printing are not sufficient. Use reason. The reason they're not sufficient is that they lack metadata, and metadata is data about data. It's rich. It's not flat. It's very important to get metadata. Reducing a digital form to paper takes something that is multidimensional and reduces it to 2 dimensions. Printing, PDFing, etc. removes information from evidence. You want to be able to know everything you can about relevant evidence, and you have a right to this under the American system of justice. So you don't only want to know the text of the text messages. You want to know when they were sent. You want to know what time of day. You want to know if a conversation was a continuance from a previous day, or if 2 months passed between conversations. 2 months passed between conversations, you want to find out if there was anything deleted in between that time. And It could have very well been deleted before anticipation of litigation. It could have been defensively deleted, but you want to know that. You want to know when it was deleted. You need the metadata for this. Like printing, a screenshot also takes data from one form to another and removes metadata contained in the original format. While a party producing screenshots may appear to be cooperating to a judge, screenshots are not in the original form as kept in the normal course. And that's what you need to be arguing to the judge. Just flushing this argument out further, because I believe it's important to be able to verbalize all of these things to a judge who may not be necessarily tech savvy. Use logic. A copy of paper is paper. A copy of text messages should be digital. The only way to be certain you have all the data behind a relevant piece of evidence is to obtain a forensic image of the device that contains the evidence. You can then argue about obtaining only the relevant data from an image. The point is, you need metadata for relevant text messages. You have a right to information regarding photographs, when and where they were taken, plus deletions and modifications of data. Another argument you can make to the judge is that in order to investigate whether there is deleted data, you will need to subpoena third parties for recipients of text messages. Argue to the judge it is best to get data directly from litigants and not involve third parties. I think that's a very persuasive argument. Options in the event of a forensic image of a mobile device. You can get a neutral forensic examiner. A judge may order a special master. And, like any other privilege and confidentiality concerns, fully imaged mobile devices can be reviewed in camera by a judge. A few notes on social media discovery. Social media discovery is its own animal, but it very much relates and has crossover with mobile device discovery, because if there are apps from common social media sites on a litigant's cell phone, then those social media platforms, the evidence from those social media platforms can be collected from a cell phone or a smartphone rather than having to go to the website to collect it. It's just another way to get at that data. Social media evidence is powerful evidence that is, again, easily deleted. It's best to find it and preserve it. Now, social media evidence is an area where you may want to gather evidence before you let the other side know that there will be a lawsuit. So you can use a forensic examiner, someone with proper tools, to go ahead and go out and find and collect as much as they can from social media sites before the institution of the action. So it may be a case where you don't want to send out a preservation letter. You want to see what you can find what you can, and then send a preservation letter to the other side. With a situation like a user's Facebook account, there are privacy settings. That particular user, not anticipating litigation, might have their privacy setting on public. You could go collect that data. You want to collect it again in digital form using a proper tool. So getting a service provider involved is a prudent thing to do in this case. It is perfectly ethical for, once litigation is anticipated, that person to up their privacy settings. They can't delete, but they could increase their privacy settings, and then you would need to go through the typical discovery process and request production of that information when perhaps you could have gotten it before litigation commenced through investigation. Find out what is out there in relation to your client in opposition. Getting a service provider involved, they may be able to go to Twitter, go to Facebook, go to Instagram, Pinterest. They may think of a social media site you haven't thought of. So that's important to consider in social media discovery. Use software and service providers or self-collect. There are websites like the Wayback Machine where you can self-collect. Mobile device forensics may be used to retrieve deleted data. That's an area where there's crossover with social media discovery and mobile device forensics. Again, when you have slack space on a phone that hasn't yet been overridden, there could be photographs, text messages, social media evidence, anything deleted could still be on the phone. In fact, consumers in general, you could do a Google search and find out how to retrieve deleted data when photographs are accidentally deleted and a consumer wants to retrieve them. There are methods out there that you can find out about online. Preserve it before anyone has a chance to take it down. And in the inverse, advise your clients, caution them about using social media going forward, but advise them of the danger of cleaning up. They can hide social media data, they can change their privacy settings, but they cannot delete it. If they do delete it, they face spoliation sanctions. And there's an excellent Florida Bar ethics opinion on this, opinion 14.1, that deals with social media and what an attorney can and cannot do in relation to advising their client regarding social media. Social media sanctions can be very harsh, anything from monetary fines, attorney fee awards, to exclusion of evidence, exclusion of witnesses, to an adverse inference jury instruction, to terminating sanctions such as dismissal of a case, or a default being entered, or the striking of pleadings, which is essentially the same thing. You want to be very careful about preserving data. With regard to the Stored Communications Act, that's a law that addresses voluntary and compelled disclosure of stored wire and electronic communications. Basically, this is a law where Google, Gmail, Facebook, all of these internet service providers are protected from having to disclose their customers' data. And there is case law where Facebook has been held to be protected under the Stored Communications Act. For example, when a user has their privacy settings in place where only friends can view their data, Facebook is not going to turn over what only friends could see to someone in the public. Therefore, it is easier to get the data from a litigant than through the platform, because a party to litigation is obligated to produce relevant information. We have a very extensive blog here at Jimerson and Cobb. One of our blog entries is here, but if you go to jimersonandcobb.com/blog, you can find many blogs relating to business litigation, construction law, and electronic discovery. So please check us out. In creating this presentation, I was given the idea by a partner at our law firm here, Brad Hughes, so I wanted to extend a thank you to him. If you'd like to reach me to discuss anything dealing with electronic evidence, electronic data, I would be happy to discuss it with you. You can reach me at sclark@jimersoncobb.com or 904-389-0050. Thank you very much for attending. I hope you enjoyed the presentation and have a delightful day.